My name is Emily Cain. I am the state senator for District 30, representing 21 communities in Penobscot County. Today I am here to present LD 1656, an act to increase safety for victims of domestic violence. As members of this committee, you know better than most that there is no quick fix, no magic wand, and no miracle cure for domestic violence. I sure wish that there was. We all wish it. This past November, a young Hudson student was killed after her ex-boyfriend strangled her to the point where he thought she was dead. And when she began to regain consciousness, he bound her with wire and duct tape. According to his own affidavit, he had sex with her while she was bound and ultimately strangled her to death with a necktie. This past Christmas, a woman in Ellsworth was killed and her husband was charged with the murder. And there are too many more examples to share. Last year, Maine police reported more than 5,500 incidents of domestic violence. State police total numbers of homicides for 2013 are available, and the facts are, again, scary and sad. According to state police, the number of homicides in 2013 totaled 24, which included one homicide that was committed in 2012, but the body was discovered in 2013, and a double homicide. Of those 24, 11, or 46%, were the result of domestic violence. In addition, domestic violence homicides were related to 4 additional deaths when murderers killed themselves or were killed by law enforcement. Since you and I have been engaged in this topic and worked to end domestic violence for many years, I bet you have the same reaction I do when you watch the news and hear about yet another incident of domestic violence. You take it personally and wonder, what else could we have done? What else can we do? This has to stop. LD 1656, which I'm presenting today, is not about a new approach to keeping domestic violence victims safe. It does not create new policy changes. Today's bill is about making the laws that we already have on the books work better and work as they were intended. The components in this bill are all improvements to existing laws that are basically working very well. These improvements are badly needed to increase safety for victims of domestic violence and sexual assault, as well as to allow the policy and the coordinated community response to domestic violence to work the way the legislature intended when we passed laws in prior sessions. These are all changes to existing statutes, and I have an additional amendment to the bill that has come to light in the past few weeks. The bill builds on current law with the following elements. First, a judicial ruling in the Thomas case this past fall related to the Address Confidentiality Act provided a new interpretation of several phrases within that act in a way that left an unintended safety loophole. This bill repairs that loophole by clarifying the protection provided to victims at high risk by keeping their home addresses confidential after they have relocated for safety. In 2012, we worked together on important changes to the bail code related to domestic violence. Some of the changes in bail procedures inadvertently left offenders who are now being detained in jail on the most serious domestic violence offenses and waiting for a judicial review of their bail, still able to call and to terrorize their victims from the jail. This bill stops the opportunity for dangerous offenders to contact and terrorize their victims from jail before a no-contact order can be put in place. Additionally, this bill integrates previously approved statutes related to domestic violence advocacy and sexual assault privilege with new legislation created in the last session. LD 1493, which came before this committee, enacts to revise the laws concerning Criminal History Record Information and Intelligence and Investigative Information Act. This aspect of the bill makes certain that information sharing between criminal justice partners and advocates can continue just as it has been done for years to ensure good risk assessment and safety planning for victims. LD 1656 today is the result of the hard work and conversations between many people, departments of state government, and organizations. The concerns about bail and advocate privilege have been discussed within the Attorney General's office, the Maine Department of Public Safety, Maine Commission on Domestic and Sexual Abuse, the Maine Domestic Violence Homicide Review Panel, the Maine Coalition of Domestic Violence, the Maine Coalition Against Sexual Assault, the Wabanaki Women's Coalition, and in January, just last week, the CLAC meeting, which just happened, and the Address Confidentiality improvements came via the Secretary of State's office. The work to end domestic violence in Maine is all-encompassing and requires all of these entities and more to turn that vision of ending domestic violence in Maine into a reality, and I'm grateful for their help. Today I am offering one amendment to the bill, thanks to feedback from the Maine Coalition Against Sexual Assault. They will be here to speak to the amendment, but it is intended to extend the provision of the bill to include sexual assault advocates as well. Your analyst has been provided with a copy of that draft amendment, and it is attached. In closing, I want to again thank you as the Criminal Justice and Public Safety Committee for your outstanding work and your ongoing commitment to ending domestic violence in Maine. This is not a partisan issue. It's a people issue that we must continue to work on together. I look forward to working with you on this bill. Many others are here to testify on the bill and offer their expert perspective. I'm happy to attempt to answer any questions you might have, and certainly will be available at the work session. Thank you very much.